Good evening. Philosopher Immanuel Kant described life's golden rule as acting only in accordance to that maxim whereby you can at the same time will that it should become a universal law. In other words, in an ideal world, individuals and states would treat each other like they want to be treated themselves. And in fact, most countries, most states agree to this. They sign treaties. Treaties not limited to the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights of 1966, Third and Fourth Geneva Conventions, and the Convention Against Torture. Within these treaties, violation of human dignity includes crimes against humanity like genocide and slavery, but perhaps the most egregious of those is torture. And the enhanced interrogation techniques we're discussing here tonight, do not be misled, are indeed acts of torture by any serious inspection. And herein lies the problem, one of the major problems with implementing a policy that my advocates are, or my opponents are advocating. That whether or not these enhanced interrogation techniques work or not, the United States has traditionally condemned, prosecuted individuals for committing the same acts that they're advocating. And the use of the evidence in these cases where torture has been obtained in the past or has been used in the past, like waterboarding, is inadmissible in court under our U.S. Constitution. It puts our U.S. military and civilian lives in danger, despite what my opponent says. I'm going to go over each one of these individually. How has the U.S. traditionally viewed acts of torture, waterboarding, and sleep deprivation, and the acts that we're discussing here tonight? Well, the U.S. first signed the Convention Against Torture in 1984, agreeing not to use enhanced interrogation techniques. And from the UN Charter of 1945 to September 11, 2001, there were no qualifications or exceptions to this rule for the U.S. The U.S. prosecuted many individuals for the precise behavior that my opponent is advocating. Waterboarding, sleep deprivation, and other techniques the U.S. has recently utilized against Al-Qaeda and other suspected terrorists are crimes in both international and U.S. federal domestic law. Now, when the United States signed the Convention Against Torture in 1984, Ronald Reagan declared that ratifying the CAT, Convention Against Torture, would clearly express the United States' opposition to torture, an abhorrent practice unfortunately still prevalent in the world today. This is Ronald Reagan in 1984. In its signing statement, the United States in the Convention Against Torture said in May of 2001, just 4 months before the 9/11 attacks, 5 months, that the U.S. reaffirmed that torture was prohibited by law throughout the United States and outlawed as a tool of authority. In every instance, torture was a criminal offense and no category of official was authorized to commit or instruct anyone else to commit torture. Moreover, no exceptional circumstance could be invoked as a justification of torture. And my opponents would have you believe that we should make an exception because of what happened on 9/11 and information that we need from terrorists. But clearly, the United States before 9/11 believed that this should not be the case. In that signing statement, the United States said that the people of the United States have believed from the outset of democracy and freedom were incompatible with torture, and the 8th Amendment to the United States Constitution, adopted more than 2 centuries previously, expressly prohibited cruel and unusual punishments. And that's what these are. These techniques are cruel and unusual punishments. Sometimes to gain information, but when you're waterboarding somebody 83 times, punishment has to be considered. Now, our opponents recognize that for such a radical change of position on torture, they have to recognize that it will not only put our relationships with our allies in jeopardy, but it will subject our military and civilian leaders to prosecution for war crimes. It's an international law. we sign treaties. We've ratified the Geneva Conventions. Just cogence is a concept in international law that says a state, whether they sign a treaty or not, must comply with the treaties that individuals and states have signed. So that means even if the United States decides not to ratify or pull the ratification out of a convention, they still can be prosecuted internationally. And in fact, it's the responsibility of states to do just that. So if George Bush or Donald Rumsfeld want to travel to Europe, they can be captured and tried in criminal courts in international law. We should not do a policy that invokes our military or our civilian leaders for that kind of prosecution internationally. Federal law, Title 18, Section 2340 of our United States Constitution prohibits torture. The punishment is whoever outside the United States commits or attempts to commit torture shall be fined and imprisoned for 20 years. Of course, my opponents might argue that, well, why don't we just make these acts legal and then we'd be fine. But there's several good reasons not to do that. And the first reason is you can't use the evidence in court that you obtain using enhanced interrogation techniques, which is defeating the purpose of what you're doing. For example, my opponent mentioned the first terrorist that was captured, Mohammed Amana Ahmed al-Qahtani was his name. We could not use his evidence that he gave to the interrogators because his interrogation techniques were uncovered by Time magazine. The Justice Department had to dismiss all of the charges because the judge said those charges are inadmissible in court. In October 2010, U.S. District Judge Lewis Kaplan refused to allow evidence obtained from Hussein Abibi, who was testifying against another suspected terrorist, after it was revealed that Abibi was subject to many of the enhanced interrogation techniques we're discussing tonight, including sleep deprivation and waterboarding. Kaplan, the judge, said, if the government is going to coerce a detainee to provide information to our intelligence agencies, it may not use that evidence or fruits of that evidence that are tied as closely related to the coerced statements as Abibi's testimony would be here. To prosecute the detainee for a criminal offense cannot use information. Ladies and gentlemen, these techniques are immoral. They are not allowable under our law or international law, and we can't use the evidence anyway. There's no reason to go ahead with the policy that's being suggested here.